Hey guys, this is Roxanne Smithers with Smithers and Ume-Nwagbo, your trusted 360 General Counsel, and this is another note from my Legalpad. So today we're going to be talking about your three options to resolve disputes. Conveniently, those three options rhyme. There's litigation, arbitration, and mediation. I'm going to give you a little bit of information about those three options, how they differ, so that the next time you are trying to either resolve a dispute that has been brought against you or deciding whether to assert a claim or a dispute on your own behalf, you can decide which route may be best for you and for your business. So first up is litigation. That's the process that most people are familiar with. That's what's popularized in television and in movies. And that's the dramatic situation where a team of lawyers come into a courtroom to argue your case on your behalf, whether you are the plaintiff, meaning you're the party who's brought the claim and is seeking the power of the court to compel someone else, the defendant, to either do something you want them to do and they're refusing to do, stop doing something that they refuse to stop doing, pay for something they're refusing to pay for, or compensate you for damages or injury that they have caused. You're going to have a judge that is presiding over your matter, and you may get an opportunity to present your matter to a full jury, depending on the type of issue that's brought or the court that you are in. For matters that you'd like to bring on your own behalf, you can most often handle those in small claims or in some areas what's called people's court. If you are a business, however, in most circumstances, you're going to be required to have legal counsel to represent your legal entity, unless you are in small claims court. Sometimes you have the option to do that yourself. Litigation is probably the process that will take the most amount of time and often can be the most expensive of those three dispute resolution options. You have the opportunities for the parties to do what is called discovery, where each side gets an opportunity to ask questions and seek information. There can be depositions, which is sworn testimony of the parties and of witnesses and individuals who may have information about the case. You can have what are called motions, which is basically written requests to the court to intervene in some way in the litigation process or to compel parties to do certain things. And the process can run all the way through you initially filing a complaint with the court saying basically, I have this complaint, this concern, this issue, this injury that this other person or entity has caused. And I need the court to help me to get a remedy from this person. All the way through jury trials and maybe even appeals to higher courts if one side doesn't like the results that come out from either the judge's ruling or from the jury's ruling. Litigation is the process that everyone is familiar with and that they've seen on television in the movies the most, and is the most expensive process. The judge or the jury ultimately makes a decision between the two parties as to who's right, who's wrong, and who will be financially responsible or in some other way responsible for resolving the issue. You're essentially evoking the power of the state, the power of the government, to compel another person or entity to either do something, stop doing something, or pay for something that you want them to pay for. After litigation, we have then arbitration. Now, the easiest way to describe arbitration is it's basically private litigation. So if in litigation you're going to the court, you're going to a government entity to compel the government to resolve your dispute, decide who's right or wrong. In arbitration, the parties have to agree to have a private individual or private entity, not the state, not the court, to decide their issue for them. They essentially give a private organization or a private individual called an arbitrator the power to sort of act as judge and jury in their matter and to resolve their dispute. And the parties agree to this in the contract between the parties for the relationship, either at the beginning of the relationship, if there's a business contract, or once a dispute arises, the parties can agree that they want to take this dispute to a private entity to have it resolved. Now, some of the reasons that parties may decide to go the private arbitration route versus the public litigation route is that arbitration can be confidential, whereas when you file a lawsuit, that is a public record. And generally, the communications and the happenings in a lawsuit are a public record, whereas arbitration is a private matter. The communications, the proceedings can be held confidential and remain confidential even after the matter has been resolved. The parties ultimately will agree on an arbitrator, or in some process that they've set up, they may have a panel of 3 arbitrators who will ultimately decide the issue. Similar to litigation, if the parties agree, there can be a discovery process, meaning there can be an exchange of documents and information and sworn under oath testimony of witnesses and interested parties. You can also have a bit of that motion practice where you are basically asking the arbitrators to make decisions, compel the parties to do different things during the sort of arbitration process. Arbitration is usually a less expensive and less timely process than litigation, depending on how many parties are involved, how complex the issues are, and whether the parties or not can agree to dates for the arbitration. That's within the parties' hands as well. Who the arbitrator is, where the arbitration occurs, the rules of the arbitration, when the arbitration occurs. And you can actually have a proceeding just like you would have a trial in front of your arbitrator. It is just a private process that the parties agree to on their own. There are a myriad of organizations that will facilitate arbitration between parties. They'll act in this essence as if they were the court administering the matter. Now, once one party is successful in an arbitration, there will be an arbitration award that the arbitrator or the arbitration panel of 3 will issue, basically deciding who wins, who's right, who's wrong, what are going to be the damages or the remedy to the dispute. Now, if one party doesn't agree to abide by that, and you have to enforce that award, you may still have to go to a court and have that award turned into a judgment so that you can use the powers of the state to enforce that arbitration award. And that can be one of the drawbacks of arbitration. If you have a party who is hesitant to participate or doesn't abide by the arbitration rule, you will still have to go to court in a scaled down lawsuit or legal action to get the power of the state to enforce that arbitration award. And finally, we have mediation. Now, mediation is the most informal of the 3 processes. Unlike litigation or arbitration, where the parties are giving away to either the state or to a private arbiter the power to decide the dispute, to decide who's right, who's wrong, and to decide on remedies, mediation is a process by which the parties come together with a neutral third-party mediator for the specific purposes of trying to work out a resolution on their own. Now, mediators are trained in the process of trying to help the parties to come to a resolution, to find some sort of common ground or middle ground that can be mutually beneficial to the 2 parties to resolve the dispute. Like arbitration, the parties have to agree on a mediator unless they decide in some process to have a mediator appointed. There are organizations that can serve as the administrative arm to help facilitate the process of the mediation. The parties will have to decide where they're going to mediate, when they're going to mediate, and the means by which they're going to mediate. And then the mediator sort of controls the actual process in the session. The mediator, unlike an arbitrator or a judge, does not make a decision, does not make a determination as to who's right or wrong or as to the value or merits of one party's claim or one party's defenses. The mediator is there to facilitate dialogue and to facilitate an opportunity for the parties to come to their own resolution. Now, mediators may bring some of their professional experience in a related industry or their experience with the law to bear to help the parties to understand some of the implications of their claims or understand some of the challenges that they may face as they pursue their claims or they pursue their defenses. But ultimately, whether an issue is resolved and how it is resolved is still in the hands and in the power of the parties. It's the last best chance for the parties to control their fate, whereas in arbitration or litigation, the parties are giving that control to either the state or giving that control to a private arbitrator. Now, in all of these categories, the parties can decide what process they would like to use to help them resolve their disputes. And often in a contract, there may be a combination. Sometimes the parties are required in their contract to mediate a matter before they're able to either select arbitration or litigation. Sometimes in a contract, one party may have the option to invoke mediation or arbitration at any point, and they can actually pause litigation so that the parties can go through these other processes. And often now, because courts are looking to expedite the resolution of issues and they are looking for opportunities to help parties take their dispute resolution power back into their own hands, the courts are often requiring that the parties at least attempt to mediate their disputes before the litigation can move forward. And that can be with a court-appointed mediator or simply requiring the parties to agree to a private mediator. But in any case, mediation, arbitration, and litigation are integral tools that parties can utilize to resolve disputes when they are not able to come to a fair and agreeable resolution of their claims by themselves. So for more information from the attorneys at Smithers and Ume-Nwagbo, you can find us on our website at STU Law Group, on Instagram, Facebook, and please be sure to like and subscribe to this YouTube channel so that you can get the latest notes from my Legalpad.